regards to the regulatory environment when it comes to the use of public space and resting in the parks. It'll be an opportunity for us to answer questions that you have. We already have a list of pre-submitted questions which are in the back. If you want to take a look at those and your question might not be addressed by that, you do have a piece of paper here. Fill out your question, get it to Karen, and we'll get that to you. During the question and answer phase, we will also be, you may also have some additional follow-up questions. Please go ahead and write those down and get those to Karen. We'll come back and get those questions answered also. I believe we have, just for your knowledge, we have a restroom right down the hall here. There's a water fountain also there. Emergency exits are 2 there, 1 in the back there. If you've got a cell phone, if you could silence it or put it on vibrate or something, that would be great. We have also, I just want to do an introduction. We have, I believe, 3 elected officials here tonight. Council President Lovelace, hello, thank you. We have also Councilor Oje, hi. And I think we had Councilor Yunker somewhere. He's here, I saw him. And there he is right there. So am I missing another elected official? No, okay, excellent. So what we've got also today for your panel.
I have a question. So if we don't have a question to submit, are we still able to make a comment or anything? Are we able to take the mic at all?
No, no mic tonight. We're asking, it's questions submitted by paper. So this evening's panel consists of myself, potentially. I'll be facilitating this along with the questions that you have. We also have Augustus Ogu, who is our city attorney. We have Chief Hensman, and we have Captain Moran. The agenda for this evening is going to be, we're going to talk about what we know from a federal, state, and local law perspective. Just mention what a state-created danger is, and then go straight into our listening and learning questions and answers. One of the things that we've had and we've noticed when we're at public meetings is everyone wants a solution. And that's one wonderful thing as a facilitator to have already as a foundation, is everyone in this room has one common thing they want. And we're all here for that good purpose. So that's a positive. What we're seeing, though, is we're seeing that there is some frustration because there is a misalignment of expectations and information associated with the regulatory requirements associated with time, place, and manner in the parks. So this evening's meeting is to help provide that information and answer those questions specifically to that. To put an analogy in it, we have everyone here caring and wanting to do positive for our community, but everyone is wanting to do so with a different set of rules. So it's like, as a coach myself, I'm thinking of it as an analogy of, all right, let's play this game. We are a team. Everyone in this room is a team. Team, council members, elected officials. We've got our community partners, they're a team, our elected officials, our staff, our citizens, and the community. We are all here for that same thing together. However, each one of those groups is playing with a different set of rules. We've got one group that's like, yes, boom, wait a second, you can't tackle me. That's not in the rules. Wait a second, you can't grab the ball, you can't use your hands. I'm trying to play soccer. No, wait a second, you can't bring a bat onto the field. That's not right. So everyone's got this weird set of rules, and so we're trying to define that and set that foundation so we all know what the rules are, and then once we have a good idea of and an understanding of those rules and we're all together on that, we could start creating positive solutions for the community. So this is a solution-based process where we first come together on the same page with the rules that we have to play with. So then as a team, elected officials, community partners, citizens, and staff can play that game and win. So I just have a brief presentation where we'll talk a little bit about that environment, that regulatory environment. I want to address quickly federal, state, and local laws to start that foundation before we start right into the questions. And when it comes to regulatory requirements, we need to look at all three federal, state, and local laws, and they have to work in unison together. So let's talk briefly about federal laws. The ones that I want to touch on is the 8th Amendment, Martin versus Boise, and Blake versus Grants Pass. Those are the three big ones from a federal perspective that we're dealing with. So when it comes to the 8th Amendment, one of the things that came up back in the early 60s was Robinson versus the state of California. And the state of California at the time had it a crime to be addicted to narcotics. And so California was sued in this Robinson versus California. And the court found that being addicted to narcotics is an illness and is something that occurs voluntarily, involuntarily, or accidentally, and that it's not a crime. And so that sort of set the stage for the 8th Amendment discussion that has occurred also in the other two federal cases that I want to talk about. So just like an unhoused individual may be unhoused either voluntarily, involuntarily, or accidentally. And that's the connection from the Robinson case. Even though the Robinson was associated with drugs, unhoused was also associated with the 8th Amendment. Martin versus Boise, and the next two cases that I'm talking about are associated with the Ninth Circuit Court. So you've got your local district court, you've got the Ninth Circuit Court, and then you've got the Supreme Court. We currently have a lawsuit that I'll talk about that's in the Ninth Circuit Court. Martin versus Boise was in the Ninth Circuit Court, and it affects all of the highlighted states that are there on the map. And there was a 2018 decision with Martin versus Boise. At the time, the city of Boise had an ordinance that prohibited camping on any street, sidewalk, or park, and the use of public property for a temporary or permanent place of dwelling. Boise also had, at the time, 3 homeless shelters, and they were all privately run, but they were reaching capacity almost all the time. So they actually had more unhoused than what capacity was available. Martin, in this case, Boise was sued for it violating the 8th Amendment insofar that it imposed criminal sanctions. Their ordinance imposed criminal sanctions against the homeless individuals for having to sleep outdoors. And it goes back to the involuntary aspect of that, of being unhoused. So with the Ninth Circuit Court's ruling of Martin versus Boise, there's a couple of things I just wanted to point out that we know. What do we know? Because as you may be familiar with, there are rulings that come out of the courts that are pretty clear. And there's also rulings that are sort of muddy, and it leaves a lot to interpretation. So I want to touch on the things that we know we can count on from a legal perspective. 1, being unhoused, you cannot criminally punish anyone for being unhoused. 2, cities are not required to build to provide shelters. That's another item that came out of Boise. It's not the city's responsibility to build a shelter. Like in Boise, there was a lot of nonprofits that had shelters going on at the time. Time, place, and manner. One of the things that came out of Boise is that cities can put into place and impose time, place, and manner regulations associated with individuals trying to find shelter. So that was allowed. And then one unique thing that I thought was interesting in Martin versus Boise is they said if cities are required to do something or communities are required to do something for the unhoused, if a city is to count it for a service that they're doing, it has to be within the boundaries of the city. So if something occurred just outside Boise city limits, that wouldn't be counted as beds for the city of Boise. So any program that is put into place has to be within the jurisdiction of that agency. So that occurred, I think, back in 2018, like I mentioned, and about 2 years later, 2020, came the Blake versus Grants Pass case. Now, in this situation, the city of Grants Pass had an ordinance that prohibited camping on sidewalks, streets, and alleys, and it also prohibited the use of bedding, tents, vehicles for temporary places to live. Also at this time in 2020, we really had very limited shelter space. And we were challenged also for the ordinance violating the 8th Amendment. The local court did side with that case. We appealed it to the Ninth Circuit Court. What came out of the Ninth Circuit Court was some more information that really expanded on the Boise case. Again, it reaffirmed that no criminal or civil punishment could occur for being unhoused. It also stated that persons, it took it another step further with the warm and dry, which was not in the Boise case. It stated that individuals who are unhoused are entitled to do what they need to do to stay warm and dry. Now, it didn't define what that was. It didn't say a tent. It didn't say a tarp. It didn't say sleeping. So there was some vagueness there, but it did expand the Boise case in saying they had the ability to stay warm and dry. And it also stated that having access to a shelter must be true and actual access to a shelter. And they cannot be discriminated upon based on age, disability, family status, if they're drug addicted, etc. So it has to be also true and actual access would be what's considered low barrier, allowing the opportunity for them to be able to go there. And if it's not truly low barrier, then it's not true access. So those were three things that were sort of expanded on from the Boise case that we found, that we discovered. So we discovered that you can't criminally punish or civilly punish being unhoused. You have to allow an opportunity for people to stay warm and dry, not fully defined. You need to have, in order for something to count, true and actual access, lower barrier, so everyone could participate in that desires that. And if it's going to count towards your numbers, it needs to be within your jurisdiction. So one of the things that changed with the Ninth Circuit Court also, to move a little bit further into detail, is the name actually got changed to Johnson versus Grants Pass. Blake actually passed away and it changed to Johnson. So that was just a technical thing. If you were going on the internet, you might find it under both of those things. One of the things the Ninth Circuit Court also did is they agreed that that it's not just enough to stay warm and dry. It now says that a person who is outside and must sleep outdoors, and they have nowhere else to go, they need to take precautions, rudimentary precautions, to stay safe from the elements. It also stated that car camping is now specifically permitted if there was nowhere else to go. So besides just a person and maybe a tent, it also included vehicles as being an ability for them to stay warm and dry from the elements. Where we are currently right now with this is there was a ruling over 6 months ago that was in favor of Johnson. 3 judges from the Ninth Circuit Court heard that. There was 1 dissenting judge, so 2-1 favor of Johnson. We have taken it upon ourselves to go to the next process, which is to ask for what's called an en banc. So there's, I believe, 11 judges in the Ninth Circuit Court, and that en banc is asking for all judges to look at it, just not 3. And then there would be a ruling based on that if that's accepted, and we have not heard if it's accepted yet. Now, we thought that once we asked for the en banc, it would only be a couple of months before they said if they would hear it or not. And we thought that we were going to get a response back in January. We're in June now. It's moving extremely slow. Not quite sure why, but we are hoping for a response to our en banc request at any time. And that would provide an opportunity for the majority of the judges in the Ninth Circuit Court to hear the case. The next step after that from either party would be to appeal to the United States Supreme Court. So until that is taken care of, we are operating under the rulings of the injunction that we have in place that states that we must provide time, place, and manner opportunities for people to rest in public spaces. So in a nutshell, those are the three big things when it comes to the federal side. Now let's take a look at the state side and see what else we need to take a look at also. There's two House bills that are very important that affect time, place, and manner in our public spaces. House Bill 3115 and House Bill 3124. House Bill 3115 states that any city or county that regulates the act of sitting or lying or sleeping, keeping warm and dry outside on public property must be objectively reasonable based on the totality of the circumstances as applied to all stakeholders, including persons experiencing homelessness. And so objectively reasonable is going to vary from city to city. But it does state that basically, House Bill 3115 puts into place what we were dealing with since the injunction in 2020. So the injunction in 2020 and our court case said, you must provide time, place, and manner. So we did so. They're able to rest in the parks. There's certain times of the day that they can rest in the park. The state, with House Bill 3115, followed that and required all the other cities in the state of Oregon to basically do what we're doing right now. They need to adopt their own time, place, and manner in public spaces. There's also House Bill 3124, which is the established campsites. 3124 required, and at the time we had, before 3124, we had the ability to post campsites after they've been in place for 24 hours. House Bill 3124 requires 72 hours notice. So it expands what was already in the books by an additional 2 days. It also states that there's certain property restrictions when it comes to either cleaning up that the cities must follow. House Bill 3124 unfortunately does not explicitly state what constitutes public property, so it leaves some of that up in the air, and there's some not full clarity on what that means. But in general, you're talking about your public spaces, which are listed there on the screen. So House Bill 3124, when it comes to, I mentioned the personal property, which was the other part. One part was it requires 72 hours notice before you can move or remove a campsite. It also states that cities need to take a look at and evaluate the property that is there and left in the public space. If it has no value, we can discard immediately. If it's unsanitary, we can discard immediately. Weapons, drugs, stolen property, etc., we can take care of. If there's value or some kind of utility still seen in that property that's laying there in the public space, we need to store it for 30 days. And it needs to be stored in the same community that was gathered in a place that's accessible or close to where it was taken. So that's some additional regulations. And again, there's an ambiguity associated with, does this have value or not? Might not have value to you, but it might have value to that individual. So we have to be careful about some of those things also. So moving forward, when we're talking about ordinances and regulations that we're looking at, and I can tell you council is actively pursuing some additional changes to some of our nuisance codes and stuff that deal with conduct in public spaces. And they're looking at doing an adoption of those rules on the June 21st meeting. So this month, we're going to be looking at a number of ordinance changes that provide additional tools for public safety to look at appropriate conduct in public spaces. When cities are enacting 3115 and also trying to comply with the federal rules that we talked about, we need to make sure that we're objectively reasonable. Whatever you're enacting, it's for the good of the community. It affects everyone. It doesn't affect just one party. And that's how you need to take a look at this. It has to be objectively reasonable and must comply with all federal and state laws. And from a House Bill 3115 standpoint, they're asking all the cities to have that done by July 1st. And some of the things that other cities are reviewing are their camping ordinances, parking ordinances, park ordinances, et cetera. Those are some of the things that are in the wheelhouse that people are looking at. So that's really from a standpoint of a foundation standpoint, some of our limitations that we have. But that brings up a lot of questions that we've heard in the city council meetings that we've received from you that we want to address to provide some more clarity with what we know. We've been talking about this quite a bit from a legal perspective. And I want you to know that tonight is a legal perspective discussion. It's not a community-based discussion. That's really the next step after we're all on the same page and we understand the legal issues and the foundation of what we have to work with. One more thing that I think is important, and it will address probably a couple of questions that you may have out there, is something that's called state-created danger. State-created danger is a situation where a city has a duty to act when it affirmatively places a person in danger, and the city needs to be aware of and responsible for its own actions when it creates that. So, an example, Los Angeles, they have an unhoused issue also. Wow, believe it or not. One of the things that happened in Los Angeles is they were camping along the streets and in these areas, and the city said, you know what, why don't you guys take the overpasses, and you can go underneath the overpasses. It keeps you out of the rain and there's some in the wind, and you're somewhat protected. The city designated that as a spot, but unfortunately, it wasn't fully thought through, and the city was sued because they placed individuals, unhoused individuals, in an unsafe environment, close to traffic, noxious fumes, and they had now the responsibility of taking care of those individuals and finding an alternative site. So a state-created danger really is, it occurs when a municipality or local entity designates a specific area for an unhoused campground or service. If you do so, if you say, okay, let's just take this area in this park is your spot, that's the only place you can go, you can't go anywhere else. You're taking additional ownership and additional risk, which is called a state-created danger. Then you need to make sure if any theft, any assaults, rapes, anything that occurs in those areas are now a city responsibility because you told them that's where they have to go. So that's a risk issue that at a council level has been discussed and that communities are wrestling with right now. Okay, enough of me. I think I've given somewhat of a little foundation, maybe some food for thought, start thinking about some additional questions. I am going to exit out of this screen real quick and put up the questions that we have right now that we have had submitted. And I'm going to go down this list. Now, we also have some that you've already submitted, and Karen has. She's going to bring those up to me after she makes sure that, oh, there's 3 people that are asking the same question. So we're going to make sure we get that organized. So your questions will also be coming forward. We're going to start off with, and we've got these in 4 main categories: code and law enforcement, public safety, Riverside Park closure, and options for moving homeless out of parks of the city. Those were the categories when we had these questions that sort of fell into place. So there's how we're starting. We're going to start with code and law enforcement. If there's questions, follow up, you can have an answer. And we answered it, but you're like, oh, write it down and make sure you get it to us, and we'll come back to that question, okay? And again, thank you very much. I greatly appreciate your participation. All right, first question. Gentlemen, are you ready? Oh, you guys are jazzed. I can see it. Let's do it. Okay. First question is, what codes can Grants Pass currently enforce in the parks? I think this one is probably good for police department.
I will take that one.
Okay.
First of all, before I answer that question, I did want to just take an opportunity to thank the community for coming out today. This is really great to see everybody out here. I also wanted to share, as the police chief, you have access to me 24/7. My door is always open. I mentioned it also at a prior engagement council meeting. You'll probably have more questions after this, and you'll want to go into greater detail. Just give me a ring. I'm always available. I will make time, and we can meet in a setting across the street and just talk in greater detail. So that's my commitment to this community, to make myself available to you, because there's a lot to take in here, and I just wanted to throw that out there. But as I answer the first question, there's a lot we can enforce in our parks, and it doesn't just live in the code section, meaning the municipal code. There's various classifications in violations of the law that are considered municipal violations and criminal violations, which are part of the Oregon Revised Statute. So I like to look at things rather simplistic. When it feels like it's wrong, it probably is, and you should call the police and we'll come out and we'll take care of it. But for some kind of simpler examples of what we might be seeing in our parks that is illegal would be consumption of alcohol in the park. It's illegal. Harassment in the park, it's illegal. Disorderly conduct in the park, it's illegal. Smoking, it's illegal. And I can go on and on. Dogs off leash, that's illegal. They're the type of calls that we would ask the community just to give us a ring, and we'll generate a call for service and we will come out. So there's a lot that goes on. And then on the other chapter, which is our Oregon Revised Statute, again, if it looks like it's wrong, it probably is. You know, people can't fight in our parks. People can't, they can't break basic type laws in our parks. Just because we're dealing with a lot of current issues doesn't mean people get to make up their own rules in our parks. So I would just ask the community that if you see something that doesn't look right, please give us a call. It's our job to come out there and make contact with that person. Sometimes there might be a good reason for why the individual is doing what they're doing, and we can educate that that's not allowed in our park. But that's kind of in a nutshell. We have a lot of authority to enforce the rules, and we have the same amount of authority to enforce all Oregon Revised Statute.
Thank you, Chief.
I guess the only thing I would add to that too is that it's not just the stuff that you guys report to us. We actually have officers that are out searching for these violations nearly every day. And when those folks go home, we have folks at night that are still patrolling the parks. So the proactive piece is huge also for us so you don't have to be the ones that are calling, that we're out there actually seeing that ourselves and taking care of it before you have to call.
Thank you. What code changes are coming for parks? And that relates to the code changes that council is going to be taking a look at June 21st. And that sounds like a legal question.
Yeah. Good evening, ladies and gentlemen. Before I get started, I'd like to echo the chief's statements. I don't want to come off sounding like I'm diminishing your guys' feelings about what's going on out here. As a citizen, I would feel exactly the same. And I do want to assure you, just like the city manager stated, the mayor and the council, they're taking steps to try to make it so that we have predictable regulations that the police can easily enforce. When it comes to what we're contemplating for our nuisance code changes, it's really a little bit more like an update. So kind of in looking through our municipal code, there was a very short section on regulation of parks and public spaces, and then there's regulation of park properties in a separate section. What we're going to be doing is we're going to be making predictable, very predictable nuisances with attached violations so the officers know when they go into the park exactly what they're looking for and exactly what the punishment is. The types of nuisances that we're going to be updating include prohibitions on disorderly conduct, As the chief said, that is a state statute, but having it in the municipal code with a readily available punishment for a violation, it makes it so it's clear to everybody what the expectations are. We're going to be initiating regulations on open flames, drugs, and drug paraphernalia. Now, just a quick piece on that. Measure 110 decriminalized use and possession of drugs in the state of Oregon, making it a Class E violation. That is less than your average speeding ticket. So when we're thinking about these prohibitions, we have to, like the city manager said, weigh it against the state laws on point. And so Measure 110 is the thing that prevents police officers from initiating arrests for those sorts of offenses. We're going to be adding prohibitions of defecation and urination to our code, which quite frankly shocked me that it wasn't in there before. We're also going to be looking at the regulation of the erection of structures and buffer zones from park amenities. So that means that there's going to be particular areas within a certain distance of a park amenity that's going to be widely used by individuals from the erection of any sorts of structures. In addition, we'll look at bolstering keeping your animals on a leash and under control. We'll also be looking at violations associated with not picking up after your animal. We will be looking at propane tank regulation and the erection of structures. So like the city manager said, we're going to be exploring these changes, and by exploring, I mean I'm going to have a finished set of rules and ordinances to council by June 21st. So my role is to get 8 of the councilors to agree on this the first time. So we're going to get it done one way or another.
Thank you, Augustus. Next question is, what action can law enforcement take against littering and illicit drugs in public parks? Police?
I'm going to start off with this one, and then I'm sure Captain Moran will jump in and provide some additional support. I think it's important for everybody to know that currently within the code section, we do have a scattering rubbish municipal code that does allow us to cite people for urination and defecation anywhere in our city. But I think, like the city attorney said, updating that to be more specific is a good way to go. But we do have that. Also, too, with basic littering, it's actually a criminal offense. In most of my career, I've really not had to deal with arresting somebody for littering. It's not very common until now. We find ourselves in a new position that I didn't really think I would consider making an arrest on an individual for littering. But we have a massive littering problem, and we've been enforcing the littering problem. Now, littering, just so you all know, you can take it a couple different ways. You can take it on an ORS, which is an Oregon Revised Statute, criminal matter, or we can do a municipal code violation, which is a violation similar to like a speeding ticket. So our police officers, the men and women out there, have discretion in how they enforce those rules. Compliance might come into play if some individual decides to cooperate. Individual might receive a violation versus a criminal arrest. And I think it's important to use good judgment, because we really do not want to be overwhelming the jail with minor offenses when we have some major issues we have to deal with in this community. So I also wanted to get that out. This is just one major issue in a vast barrel of crime and problems that we have in our community that we face on a regular basis. So that's kind of the littering piece. The illicit drug piece is going to shock most of you in this room. And I'm going to talk a little bit about ballot measure 110, and it's no secret that I'm not a fan of ballot measure 110. And some of you in this room may have voted for ballot measure 110, and it's no judgment whatsoever. My opinion is that there was, the way it was scripted led communities to believe that we would have buildings erected almost immediately to help people work through their disease of addiction. And I support that 100%. I want to help encourage people into treatment. And we do that on a regular basis. Law enforcement has been doing that for years. The problem with law enforcement and people in our community that are dealing with addiction, there's no trust because we arrest a lot of people that are suffering from addiction. That's just a fact. With that said, ballot measure 110 decriminalized user quantities of meth, heroin, fentanyl, all the biggies. So when there's people in our parks with user quantities of fentanyl, all we can do is write you a citation. That citation is equivalent to a Class E violation parking ticket. Okay? The individual that receives that ticket has an opportunity to call for a case screening, call the Lines of Life, which I support. I want people to call Lines for Life. In fact, we took it to the next level and we printed the Lines for Life number on the citation. So we want to encourage people to make the call and seek treatment. The reality is the majority of people that have received tickets for ballot measure 110 do not make the phone call. And that's a very long discussion. But I think it's important for you all to know in this room that your police department leads the state in the number of ballot measure 110 citations. I think we're over 1,000. This is not a badge of success, ladies and gentlemen. This is because we take this serious. We do not want drug use in our parks. We do not want drug use in our community because we know what happens when people are dealing with addiction and that unpredictability that occurs when you're high. We don't want that in our community. We want to help, though. We do want to help encourage people towards treatment, which is what we do on a regular basis. So we took a stand from the very beginning that we will issue citations. There's some wiggle room, there's discretion. Our police officers will tell you if they decide not to, they may not do that. But the vast majority of time, we issue those citations. I think the next city that comes up against our numbers would be Medford, and then your bigger cities up north. So that's what we're doing. Also, if we issue a citation connected to ballot measure 110 to anybody within our parks, because it's a state statute, because it's a state offense, our municipal code gives us the authority to trespass that individual from that specific park for 30 days. That individual does have an appeal right, which folks use, and I appreciate that, and I would encourage that. But that's kind of the illicit drugs in the park question. But there's more. And I think the community needs to hear this directly from me, that yesterday, the 11th person overdose died in our city. Last year, we had 11 total in the entire year. So we're June 1st, and we've already hit 11. We've also had 83 overdoses year to date. Last year, I think we were at about 98. So we are going to shatter those records. And nobody escapes this. Yesterday's was a 20-year-old female. A couple of weeks ago was an 18-year-old male. And there's plenty of other age groups within those 11 people. So we will do and continue to do everything we possibly can to help somebody make a different turn. We have a program at our department that most people don't know about called the New Way Home. We want people to walk into our department and say, please help me get into some sort of treatment. There's a lot of money out there that is being shared with our behavioral health resource networks, and it's important that we help one another navigate this crisis that we're in, because it's a crisis. I know there'll be more questions on this, and I would expect that you call me later, because I would be happy to have a further conversation about this, but we don't have a lot of time, so I'm going to cut that one short.
Thank you.
Yeah, we were excited when we got the New Way Home program started a few years ago. And when ballot measure 110 came in, it overnight pretty much ended that, because it was a safe surrender of narcotics that you could bring into us and we would get you treatment. So overnight that was pretty much rendered useless. It also really affected our narcotics dog program. We had a dog that we had purchased through donation and sent a handler off for training, and got him up and running just in time for that law to come into effect. So it's got a lot of unintended consequences, and I think that anyone that works the street knows that it's been an abject failure. Even the folks that are in treatment communities and those that have gotten clean said they would never have gotten clean if there was not somebody or something over their head waiting for them to go to prison, or some outside influence to get them clean. So I guess that's enough about 110.
Thank you. Next one is, can the city of Grants Pass keep groups from supplying syringes and needles, food, and clothing?
So there's a joke among lawyers that their favorite answer is it depends. I hate using that phrase, I really do. But it does depend. So there's an abundance of case law surrounding food, disseminating food and clothing. That has been found to be protected First Amendment speech. That said, there is a way, I believe, that the city could create a permit process so that the city, at the very least, knows what the activity is, where the activity is being held, how many people are expected to be at that activity, giving out food or clothing, and perhaps some forum to ensure that the park or wherever they decide to have this activity is cleaned up afterwards. So that's something that I intend to bring forward to council in short order. It won't be with the 21st changes, just because it's going to be a little bit more involved, and I want to make sure that the city as an organization is protected from any challenge when it comes to that. As far as syringes and needles, I believe that that's a different question. I don't want to make a legal conclusion, because I'm not sure that, I think that reasonable minds could disagree, right? There's an argument that passing out syringes and needles can't be protected by the First Amendment because it facilitates breaking federal law, basically. You're breaking the law by injecting controlled substances like heroin, meth, fentanyl. There's no provision for illegal conduct. And then there's the flip side of that argument, where people would say, there's a lot of research out there that shows that it stops the spread of bloodborne pathogens, therefore it should be adequately protected by the First Amendment. These are things that I'm actively trying to explore, and again, I'm trying to, I want to bring this to council in short order in a package where all of them are unified behind the decisions that they're making. I think that that's one of the most important things that we can do as a professional staff, Aaron, the executive team, and myself, is to try to provide solutions where, one, we're working in the best interests of the most people in the community, and we're working on a unified front from our city council and our mayor. But that's something that I'm actively looking into, and I do intend to bring something forward to council in short order, hopefully within the next few months.
Thank you, Augustus.
Can I just make a
Chief?
quick comment on that, Aaron? I just wanted to make sure that the community knows too, when we talk about addiction and ballot measure 110, your police department knows we cannot arrest our way out of addiction. We know we're here to help community. But I just wanted to make sure I said that because this conversation can sometimes go in a couple of different directions. We know we're not going to arrest our way out of addiction. We want to help people and guide them into treatment. So I just wanted to comment on that.
So I think this one's for Augustus also. Is Reinhardt Park going to allow homeless campers?
It will not, under the terms of our injunction or otherwise. Everything that can be done will be done to keep that park free from camping.
So in the injunction, what he's talking about, it states that people are allowed to rest in the public parks except for Reinhardt Volunteer Park. So that one is excluded from the opportunity to rest. So why is the city allowing tents in parks?
So that's a kind of a complicated question too. And this is something that we've been wrestling with here with our outside counsel and within council chambers, talking with the city council. So tents are the most widely used form of shelter by homeless individuals. There's a lot of considerations in determining whether to just do a full-on ban on tents. So first are the federal lawsuits that basically provide that individuals must have the implements to keep themselves warm and safe and then protected from the elements. It would be an unnecessary risk at this time, given our current litigation, to make really substantial changes that touch on sleeping or resting in our parks. And I'm sure we're going to talk about this a little bit more, but what we're trying to prioritize as a city is focusing on conduct that is not consistent with what is expected by the community in our parks. We're wanting to address conduct that is detrimental to the use and the beauty of the parks. We're trying to focus on conduct that will allow everybody, citizens and homeless individuals alike, to enjoy the privilege of using the parks in a clean and safe environment. That is the city's goal. So in terms of just a full-on ban on tents, that's not something that's the extreme on one side. And then the extreme on the other side is saying tents are always allowed 24/7. We think that there could be a middle ground that, one, complies with the spirit of the orders that we're under, the court orders that we're under, to treat or to allow people to have the proper things to keep warm and dry and protected from the elements, which also preserves the public's use of park amenities. And that is something that we are actively exploring, and I will be bringing to council on the 21st.
So as a follow-up question, because it plays into that, and we may get that, but I'm going to follow up on it now. Is there anything that we're talking about that for Riverside Park, for allowing tents in the park, that may be looked at on the 21st?
Yeah, so on the 21st, what we're exploring as a first step is for the erection of structures, which includes tents. The erection of structures will not be allowed in Riverside Park east of 6th Street. We're going to do this at Riverside Park only initially. That would allow us to see kind of how this would play out on a larger scale and to see if we can replicate it at other smaller parks. The issue really is the size of Riverside Park. That makes it a little bit easier to try something like that there. But we are active, we're going to want to see how that works out first, and then we're going to want to reassess, take in data, and see if there's ways that we can improve upon it while also complying with the spirit and the word and the letter of the injunction.
Thank you, Augustus. And again, those are things that are being brought forward for council consideration on the 21st. Moving on to some public safety questions. Who determines what is considered safe and unsafe?
That's a good question, and Todd and I, Captain Moran and I, were actually chatting about this one before we came over. It could be something as, we talked about a storm. If there's a bad storm coming in and we're concerned about trees falling or power lines falling, our police officers do have the authority to immediately close down a park, for example. But I think the question here is really laced around, you know, it's subjective, what's safe and what's not. The threshold has to be a little bit greater than a feeling, of course, and I think what we saw occur just over the last couple of weeks was because we hit rock bottom. We're not going to just arbitrarily, because there's a couple of things occurring in one area, shut down a park or shut down a facility. We had a protracted amount of crime occurring in Riverside Park. And unfortunately, it ended with the death of a man, and that was essentially the straw that broke the camel's back. But to answer that question in its simplest form, the police and the city manager.
Thank you. Next question is, when observing violations in the park, what's the best number to call? 911 or the non-emergent number?
Well, I guess it's kind of up to you on how you feel the situation is evolving. If it's not an emergency and you don't get that feeling like there's an immediate intervention that needs to take place, then likely the general business line, which is, if you guys are ready, I'll give it out to you guys. It's 541-450-6260, and that's the non-emergent line. Of course, you know the emergent line if you need to call that one too. So really, I don't want to say one way or the other, but it's kind of how you feel in the moment. And if things change after you make the first call, there's nothing wrong with then calling 911 if something changes before we get there.
And to kind of piggyback on what Todd said, it's natural for us all to not want to call the police. I know you don't. You'll see something and you'll question whether I should call. If you even are tick, tick, tick thinking that, you should call. That's our job. We want you to call. We will respond to every single call that the citizenry make. We'll prioritize it, of course. But if you see it and you even for a second think, I should probably call the police, you should make the phone call. And I'm embarrassed to say, even as a cop, I've thought like that too. I don't want to bother them, they're busy. No, that's what we're here for. Make the call. Definitely decide whether it's emergent or not. Majority of the time, it's a non-emergency number. But I would ask to please make that phone call.
And definitely to reinforce that, ever since the chief has been on board, what, almost 5 years now? 4 years?
4 and a few months. If you'll
Okay.
have me for a couple more, I'm good to stay.
One of the refreshing things is he is extremely data-driven, and he does proactive enforcement and focuses that on data. Where does he get some of his data? People calling in. So that's an important piece.
We have an incredibly friendly staff in records and dispatch, so they will be happy to hear from you.
Thank you. All right, moving to Riverside Park closure, which is, we have 2 questions for that. The first one is, what is the plan for our other parks which will be unavoidably impacted? Morrison Park is on the thrones of baseball season. The city is pushing the homeless out into even highly congested family-occupied neighborhoods.
I'll get us going, and this one might take a while because Todd and I will definitely go back and forth on this one. Because he mentioned it earlier, we always have a plan. We're always thinking 3 steps forward. We're always thinking what's going to happen in a couple weeks. And Todd mentioned earlier that our patrol teams, when they have discretionary time, they're foot patrolling our parks. I mentioned at a council meeting, most of us aren't up at 3 a.m., but our folks are up at 3 a.m., and they're out there actively patrolling areas that are needed to, that extra patrol is required because of something that happens. We know that displacement theory occurs all the time with everything, meaning if people were in Riverside Park one day and we closed the park, they're going to go someplace else. And some of the other parks right now are a little overwhelmed. Tussing, Morrison Park are 2 that come to mind. In fact, the overdose I spoke to yesterday was at Morrison Park. The overdose death that I spoke to happened there. So what are we doing? The city manager mentioned data. We're always looking at the numbers. We're always looking at what's going on. We're always trying to be predictive, and we're always trying to use our intelligence to thwart, to slow down, to hinder. That's just what we do. The city's not that big, so to come up with strategic plans to impact problems isn't really that hard, meaning we meet regularly anyway, every single month. We do something called ILB. It's an intelligence-led briefing. It's kind of modeled after CompStat. And that started with Bill Bratton in New York, and it's basically just modeling. We do that too. But as the chief and as Todd in a captain role, as an executive leader, we hold our team accountable and we expect action. So we don't just sit around the room and talk about numbers without coming up with a plan. So we've already done that with these parks. I've already asked the right people, please make sure the teams are utilizing their discretionary time to be in specific areas. But it's actually not just the parks. We manage regularly problem houses. There are plenty of problem houses in our community. So how do we monitor a problem house? Well, that means if we've been to some place more than 3 times, we've noticed. We've been to some houses, well, it's odd, 10, 15, 20 times. So that is now a project because something is occurring that is of criminal nature in our community that we have to do something about. The stuff with the parks was just instinctive because we just knew that level, that amount of people are going to go someplace else, and we are going to track that and keep an eye on it. Remembering as well that unhoused people have rights too. So the police just can't go and walk around the parks and be accusatory, let's say. So, but we will be there and we will be monitoring for behavior problems. And if people's behavior elevates to a crime or a municipal code violation, we'll handle it. And with our current city code, if anybody receives, me included, 2 citations, municipal code citations, within a year, we can trespass you from that specific park for 30 days. Anything else, Doug?
Well, that was one of the changes that was also mentioned in the injunction. Was before we didn't have a due process piece, and so we had to change that, and that was the appeals hearing. But it also said that we can't trespass them like we used to. We would trespass people from every city park based on those 2 city ordinance violations or 1 state violation. So those are the changes that we have had to implement. And I just want to say that our community response team officers, Artoff and McGinnis, are out there every day. They know just about everybody by first name. You guys probably have met some of you. And we also have entered into a private-public partnership with Options. And so we have a drug and alcohol addiction counselor that goes out with our community response team and meets folks where they're at and see, if they maybe can get a leg up out of where their current living is, finds them. So it's not just about enforcement, it's also about giving people opportunities to get out of where they're at.
And I'm going to just add to that, shout out to that partnership with Options for Southern Oregon because her title is case manager and she's absolutely brilliant. She's helped just a ton of people that we at times thought couldn't be helped and helped them get to a space where they're doing better. So shout out to that partnership. But I also wanted to share too with this community and anybody that's listening, we try to utilize technology as best that we can. So we do have online options to report maybe suspicious behavior. So jump online. It's you just go to our main website. You might have to scroll down just a little bit, but then it starts blinking at you. We have it in English and we have it in Spanish, and we kind of have it bounced all over the place. And we're trying to make that more robust. So you all, anybody in the community can just jump on there, add a picture, tell us what's going on, share with us what we need to hear, because this all gets embedded into that ILB, that intelligence-led briefing that we do on the regular. And we're getting pretty good at it now.
Thank you. Yeah, you guys in blinking lights, I tell you. Are other parks beside Riverside Park going to close?
I'll take that one. That's a good question. I don't know. And I hope not. I really do. I really hope they don't. But we're paying close attention. And I'll be I'm always transparent, and I will always tell you what's on my mind. When you congregate people, problems happen. I think back to when I had a roommate, didn't quite like it. So unhoused people that are living in mass in our parks feel the same thing. So I'm concerned about that. I legitimately am concerned about that. We had a menacing issue recently. Menacing could be where one person menaces another person with a knife or displays a gun or something like that. But we've had that occur in a park recently where nobody wants to be a victim. And if nobody wants to be a victim and somebody's menacing another person, there's not a whole lot we can do. That happens regularly, so we keep a close eye on that as well. And anything else?
Yeah, I'd just say if that type of situation takes place where you're a witness to that, we can pursue disorderly conduct charges on individuals that are involved in violent and tumultuous type of activity. So, but we do need someone to stick around and say that you witnessed it and it did kind of frighten you. So just be part of the solution.
All right, thank you, panelists. Moving on to options for moving homeless out of our parks of the city. There seem to be quite a few questions there. What about the Gospel Rescue Mission? Isn't that a shelter? And can we tell them to go there?
So you can suggest that somebody goes to the Gospel Rescue Mission. I don't think that anybody in here would disagree that the Gospel Rescue Mission does great work and that it's changed lives. However, the U.S. District Court did not consider the Gospel Rescue Mission a valid shelter, and even if it did, it stated that the number of spaces that it had available was not enough to accommodate the number of homeless people in the city of Grants Pass. Now, I want to read you a direct quote from the U.S. District Court opinion. This is by Judge Mark Clark. This is his assessment about why the Gospel Rescue Mission doesn't count as a low barrier shelter for the purposes of sheltering the unhoused. The Gospel Rescue Mission is the only entity in Grants Pass that offers any sort of temporary program for some class members year-round. However, Gospel Rescue Mission cannot be included in the mathematical ratio of homeless people to shelter beds because Gospel Rescue Mission has lost its designation as a HUD-certified emergency shelter. Gospel Rescue Mission is also considerably less accessible than even the shelters in Martin because it does not offer temporary emergency shelter and has substantial religious requirements and other restrictive rules. Gospel Rescue Mission does not offer emergency shelter, only a 30-day residential program. The program offers extended stays and is more akin to a transitional housing program than a homeless shelter. Additionally, there are several strict rules for residents of the Gospel Rescue Mission, including remaining nicotine-free while on or off the premises, and mandatory attendance to Christian church and other church-affiliated activities. Even without these rules, the Gospel Rescue Mission's 138 beds would not be nearly enough to accommodate the at least 602 homeless individuals in Grants Pass. So that isn't the city saying that the Gospel Rescue Mission is not an option. That's the court saying that it's not an option. So it is a shelter, but it's not the kind of shelter that the U.S. District Court or even Martin versus Boise, the court case that Aaron talked about earlier, contemplates. What that contemplates is what's called a low barrier shelter with basic rules for conduct, but it doesn't require somebody to be clean to get shelter. It doesn't require somebody to not be intoxicated and get shelter. What it provides is shelter first, ask questions later. That's what low barrier is. It doesn't mean that there aren't any rules, but it's shelter first, questions later. So that's why the Gospel Rescue Mission isn't considered a shelter for the purposes of our analysis.
Thank you. How large would a shelter need to be to allow the city to actually say you can't be in the parks and...
Yeah, so this is a very interesting question, and it's every time I explain it, people get wide-eyed, but this is important for all of you to know, okay? So in this U.S. District Court case, UCAN conducted a point-in-time count of all the unhoused individuals in the city of Grants Pass. That count came out to 602 homeless individuals, involuntarily homeless individuals, meaning that those people didn't have anywhere else to go. They didn't have family in the area, they had no access to low barrier shelter, and they had no choice but to be outside. Now, if you're invoking the logic of Martin v. Boise, I'm going to quote this U.S. District Court case again, because this gets to the central holding in Martin and why this is a really strange standard, and in my opinion, an impossible standard. Quote, because Grants Pass lacks adequate shelter for its homeless population, its practice of punishing people who have no access to shelter for the act of sleeping or resting outside while having a blanket or other bedding to stay warm and dry constitutes cruel and unusual punishment in violation of the Eighth Amendment. So if there's not adequate shelter for the homeless population, they can't be punished. They can't be given a civil citation. They cannot be criminally charged. So the strange answer to that, if there's for the sake of answering the question, if there's 602 homeless individuals in the city of Grants Pass, that shelter would have to accommodate 603 individuals. If that money magically fell out of the sky for the city council to engage in that, and they built a 603, let's just say 650 bed shelter, there's not going to be anything that stops another group from coming and saying, actually, your point in time count is vast undercount. There's actually 1,000 homeless individuals in the city of Grants Pass. And let's just say that same parachute of money falls down, and then we build a 1,500 space shelter. Well, there's a drastic miscount of the point in time count. You actually have, it's theoretically impossible because the number will theoretically keep growing. And I believe that that's part of the reason that this Martin case did not dictate that the city was responsible for building shelter, because I think that the judges in that case had an idea that that's how that would play out. So it would have to be a big shelter. Another thing that we're not sure of is whether an urban campground would count, because that's not something that provides temporary shelter. It's the distinction between shelter and space for people to go. So it's actually unclear at this point in time whether an urban campground would even count towards that shelter space.
Thank you, Augustus. Next question. Can the city of Grants Pass designate one or two parks or pieces of property they own to send the homeless people to?
So the city could do that. However, we have to weigh the efficacy of doing something like that against the interests of the taxpayers. So as members of your city government, we're the stewards of your taxpayer dollars. That means that we have to be extra careful as to what we spend those taxpayer dollars on. This is also something that I think has come up a lot as an obvious solution. Well, you just designate a lot for these people to go and just put them there. It isn't as simple as designating a lot, and I'll tell you why. You designate a lot and you say, this is where you need to go. If you want to camp overnight, if you want to sleep or rest overnight, this is where you must go. If you send homeless individuals to a bare piece of land, even if it's really big and it accommodates a lot of people, they're going to need amenities. They're going to need bathrooms. They're going to need washrooms. They're going to need things that basically allow them to keep their dignity so they can wash, they can be clean, right? These are the things that would fall on the taxpayer to supply.
Yeah, let's please be quiet.
So we're talking about devoting significant resources, not even just things like that, but we're talking about officer time. We're talking about full patrols all the time. That's a difficult thing to do. Coupled with that issue of security is the potential liability that the city may be exposing itself to. As I said before, the city, we're the steward of your taxpayer dollars. We do not want to be in a position where we own or operate a designated place where the city owns the property to operate a campground or a shelter of any kind. We're not sure of a few things. One, we're not sure if our insurance company would cover something like that. And if our insurance company didn't cover something like that, and we exposed ourselves to that danger by making people congregate in a common area where we're not adequately able to vet them, again, this is a resource question. If we're not able to adequately vet them, we know that there are people that are not homeless by choice. We know that there are people that are homeless because they're mentally ill or have some sort of mental illness going on, right? There are people who are homeless because they have a substance abuse issue. And then there are people who are homeless because they choose to be homeless. There are people that are vagrants that choose to be vagrants. What would be happening is that we'd be putting all of those people together. We wouldn't be able to adequately figure out their criminal history prior to, because we'd be designating the space. If something were to happen at a designated space like that, and our insurance company didn't pick it up, we all, the taxpayers, are going to have to pick that up. I'm one lawyer. I could defend a case if I were part of a firm with firm resources, but I am one individual in the legal department for the city. I don't have a legal assistant. I don't have paralegals. I don't have a deputy city attorney. It's just me. So I couldn't do the case by myself just by sheer physical impossibility. All the paperwork that would need to be done, all the discovery that would be involved. And if our insurance carrier didn't pick that up, we would have to hire an outside law firm. And that is hundreds of thousands of dollars. And if you lose, it's even worse. So when we're talking about the designation of a place, the city staff and the city council are weighing what the potential risk is versus the potential risk to the taxpayers. So it's not something that we take lightly. It's not something that we're dismissing out of hand. There is a lot of thought that goes into it. And we're trying to the best of our ability, to protect the taxpayers from having to shoulder the burden of something that will be a money pit for all intents and purposes, a money pit. The city doesn't have a way to pay for that. So we're weighing all of these issues together to try to come to a solution or to try to come to an understanding where we're not taking any unnecessary risks. We understand the burden that it puts on you, but we also would understand the burden would be a lot worse if we weren't able to be covered under something like that, and we're not sure that we could be. And that's just the plain facts. Like the chief, I want to be transparent with all of you too. I don't want to sugarcoat it. We don't know. And so that's an unnecessary risk for us to take with your taxpayer dollars.
Thank you. That's a good example of the state-created danger that we talked about earlier that would go to in alignment with that question. Could Grants Pass lease or privatize the parks so they can then remove unhoused people?
Drinking water because it's a long response. So this question has come up a lot, and I have addressed it a lot. And the answer to that question is basically no. That's not how our system of government works. That's not how municipal functions work. So there's a couple legal reasons, and then there's practical reasons, which I'll get into. So the first is if you were even able to privatize the parks, and I mean, I'm not saying legally that you couldn't. Legally, sure. I don't think there's an issue with that. But even if you did, you still have the overlay of state law that prohibits law enforcement from removing a camp without 72 hours notice. A private actor who owns the parks would be conducting what's known as a traditional municipal function. So that's something that the city traditionally, or any government traditionally, takes care of as its in its day-to-day business. Parks maintenance is one of those things that cities all over the country have traditionally engaged in. That's something that they do. But when you're engaging in a traditionally municipal function, the Bill of Rights will apply to a private actor who owns those properties. So if a private individual owns, say, Riverside Park and starts to have private security go out and give citation, just saying if the cops aren't involved, and I'll get into that in a second. The analysis in Martin v. Boise and Johnson and Blake wouldn't change, because it would still be a theoretical Eighth Amendment violation against somebody's, against cruel and unusual punishment and excessive fines. The landscape really wouldn't change too much. So that's part number one. Part number two is, even if the parks were privatized and you magically banned camping in the parks, the fact is that homeless individuals are going to go somewhere else. And as you are seeing being played out in larger cities like Los Angeles, Phoenix, Portland, Seattle, they're going to go to the street corners. And there's not going to be anywhere to go because the parks are theoretically privatized to keep them from sleeping and resting during resting hours. I don't think, I'm just putting my finger on the pulse here, I don't think that that's something that the citizens of this community would want or expect. Homeless individuals aren't going to just move along. They're going to find another place to be. Third, assuming that the city was the parks were under full privatization, that means the city would have to take itself completely out of the equation. That's not just administration, but it's maintenance. Who's going to cut the grass? Who's going to maintain the facilities? That wouldn't be something that's in the city's purview because of the state-created danger issue, and because we don't want to have we wouldn't want to have the liability of even being anywhere closely associated with the park. So it would be a massive burden on the taxpayers, frankly, to live in a community where, hey, the parks may not be maintained the same way. They may be maintained better, who knows? Somebody has a lot of money, that might be the case, but the cops aren't going to show up unless it's life or death. People are going to have to hire their own private security. So it's a this is not to mention the fact that if privatizing the parks was a solution, up and down the West Coast in the Ninth Circuit, you'd see the privatization of parks taking place everywhere. The fact is, it's not a solution. It's not a practical solution. And the court wouldn't look favorably upon it either if the rationale for privatizing the parks was to keep homeless individuals out of it. It would be viewed as a way to end run around the injunction. And that's what we want to avoid. We don't want to take any sort of unnecessary risks that will make the community have to suffer even further than it already has.
Thank you. I think you've probably answered the next question with your last couple of sentences. Can the city close all parks until the homeless migrate out of town?
It would be a direct violation of the injunction to close all of the parks. The injunction very clearly states that sleeping and resting is allowed in all city parks except Reinhardt Park between certain hours.
Okay, thank you. Similar question, why can't the city force homeless people to live outside of our cities since they pay no taxes?
So I think I brought up earlier, there's different tiers of homelessness. There's people who are down on their luck, people who have mental illnesses, people who have substance abuse issues, and vagrants. People who don't want to be homeless and don't want to sleep in the parks, a lot of them do work. And while they do work, they do pay taxes through their payroll tax. The only difference is they don't have shelter and stability. So those people do contribute to society. There are people that are houseless who don't want to be there, who are in our parks, who are following all of the rules, who are being good neighbors that don't want to be there. I think the chief and I think the police would back that up. The way that I'm going to say that, I'm going to try to think of a good way to say this because I want people to understand, you know, we know homeless individuals have rights. You do too. You have the right to enjoy the privilege of going to the city parks that your taxpayers pay for, your taxpayer dollars pay for. It is not American to say that based on your status that you need to get out of town. That's, it's not something that, it's not a government that I would want to be part of. And I think that most of the people in this room who believe in freedom of choice and believe in what this country is about would agree with that. It's not a realistic solution. The homeless and the poor will always be among us. What we want to do is we want to balance the interests of the taxpayer citizens and their use of park amenities with what the injunction says and allowing people to sleep and rest, which is something that every human being has to do to survive. And that includes going after bad conduct. That includes enforcement to the fullest degree that we can. And that means, and in doing that, you're going to make the park safer for all of you and for unhoused individuals who are trying to get out of their situation. And that's the goal. So it's not a realistic solution to just say, hey, based on your status, you got to get out of town. It's just not a good thing to do, and it's not something. It's again one of those things that could get the city into trouble, and we don't want to do that to you guys.
So Augustus, the next one is really along the same lines. I think you probably answered it, but if you'd like to add anything to it, can the city provide bus tickets to the unhoused so they would leave town?
So that's kind of like shifting the problem. I think that if you are buying a bus ticket for somebody with a purpose, right? So they have family across country that is willing to help them. They have family across the state that's willing to help them. That could be a viable solution. But providing a ticket for somebody out of town, it's not just out of town just to get out of town. It's not a long-term solution. That happens all up and down the West Coast just because there's great weather on this part of the country. But it's just, if the goal is to connect homeless people with services or family, it might be viable. Otherwise, it's not a long-term solution.
And we do that, actually. Our community response team, if they have someone that says that they have another place to be, they'll make sure that that's the case, calling those individuals, making sure that they will take them when they get off the bus, because I'm sure that we would not appreciate, folks getting off the bus here. We don't want to do that to another jurisdiction either. So we make sure that they have somewhere to go and someone to greet them when they get there, and we will purchase them a ticket.
Thank you. Can Tussing Park be considered part of Reinhardt Park?
Not that I'm aware of. I don't think we've had those discussions. Not that I'm aware of, though.
In the Parks Master Plan, they're considered two different parks, so they'd be classified that. And to add that or change that designation as Reinhardt Park would be seen potentially as a violation of the injunction that we're under right now. Okay. Time, place, and manner questions. We've got a couple here. How can we restrict where the homeless camp? What about around schools?
So it's helpful to think of this in terms of bubbles. There's the bubble, Oregon, and then there's the bubble Grants Pass. We're in a different legal landscape than the rest of the state when it comes to the time, place, and manner regulations. And that's mostly has to do with our federal case. I think that under our current framework, there's a way to, again, buffer uses and buffer areas for resting and sleeping. However, we're not really going in that direction. Again, what we're trying to do is focus on conduct. However, it might be a byproduct of the legislation that council is going to consider that those areas are going to be a little bit more free and opened up for schools and for kids and all of that. So that's what we're kind of seeing. The reason that we're not pursuing time, place, and manner regulations the same way that, say, Medford or Ashland or other cities across the state are doing is because our injunction deals with our current camping ordinances, which we aren't able to enforce. So we don't want to risk changing those, we don't want to risk changing those ordinances because we don't want to moot our case at the Ninth Circuit. So that makes it so that there's no controversy to be heard before the Ninth Circuit. The consequence of that is leaving bad law in Martin versus Boise as the law of the land of the Ninth Circuit, and leaving Johnson and Blake versus Grants Pass as the law of the land in the Ninth Circuit. And really the end result would be the same. If that were to happen, all we would be doing, we would just fall in and we would be doing time, place, and manner regulations for where people could sleep and rest. So I think the city manager noted at the very beginning that this is kind of an experiment. We're the test case for this, and we've been going through this for the last couple of years. We're a picture of a failed experiment. So we've been doing time, place, and manner regulations for the last couple of years. It's really strange to say, but it's true. Not too much would change. Not too much would change, especially if we mooted our case. And there's a lot of cities that are watching across the country, not just in the Ninth Circuit, but across the country that are watching our case very carefully. We are the proverbial tip of the spear, and we've gotten very far in the process. And to do something to moot our case, we have our insurance company has hired counsel that is taking this case on basically for free. To moot our case at this point would be counterproductive for everybody.
How does this affect sidewalks and walkways downtown? And do we still have an opportunity to make sure ADA minimums are met?
I think we do. So, and this is, in a way, using the injunction as a sword, right? So the injunction says that city parks need to be open for people to sleep and rest during certain hours. That means that if an individual is sleeping on the sidewalk, if they're sleeping in a right-of-way, sleeping in an alley, they have an alternative place to go, and that's a city park based on the injunction. And so it would be up to law enforcement at that point to say, hey, this is where you can't be here, and there is an alternative space for you to go. And I think that that's dealt with in terms of what is that? DOC, right? Disorderly conduct. So this is an instance where you would use the injunction as a sword and say, based on this is where you can sleep and rest at night. The sidewalk is not an appropriate place to sleep or rest. So I think that's how we would keep the sidewalks clear under our current environment. So that's how I think that we would meet the ADA minimums.
Thank you. Can we limit the number of tents in a given area?
I believe that we can, and that's something that council is going to be looking at our January 21st meeting. So because we don't want to take the unnecessary risk of doing a full-on tent ban, we think that there is a way to accommodate, again, park use and individuals who want to sleep and rest. And so, as we stated before, Riverside Park is going to be a real test case for this method. So no structures will be allowed to be erected, again, east of 6th Street. They will be allowed only on Riverside Park West, so west of 6th Street. There are options we're looking at in terms of buffering from park amenities, playgrounds, splash pads, sports parks, where the erection of structures cannot take place. And so these have to be rules that are equally applicable to everybody. We cannot target one demographic over another. So we are making sure that everything is in order legally in order to make sure that these are changes that we can make. And I think that we're going to see a little bit of change in the right direction that will possibly enable us to make larger scale changes down the road while complying with the injunction and our court case.
Thank you. A couple of other ones, and we get to the questions from everyone who participated today. The first one is, what are the possibilities for placement of porta potties in parks with no restroom facilities? So I could take that one just briefly here. That's more of a policy decision. So that'll be something that council would want to take on as a discussion. We did discuss at one time the additional porta potties in Riverside Park, and we did place some additional porta potties out there based on council direction. So something like Debo Park, which currently has a playground facility and open grassland but does not have a restroom, if the community and or council would like to place one there, then we would get direction from council to have one placed there as an additional level of service. Do want to note, though, also from a restroom perspective, is we are installing 2 Portland loos in and around the downtown area, which will also help with some of that. And the remodel of the Welcome Center is going to have 3 additional outside restrooms that are attached to the new Welcome Center. So that'll also help with restrooms in the downtown area. Is it possible to place a day use fee on city parks?
I think so, but I'm not sure what the issue is that would be fixed. There's individuals in our community who are not homeless that have limited means to use the parks, and they have children and kids and want to go out and enjoy the parks that they pay for as well. It would be, I think legally you could do it, but I'm not sure that it would fix a problem. You would be having issues with the injunction that says that the park has to be available for people to sleep and rest. Legally, sure, but I'm not sure what problem it fixes.
Okay, thank you. Another question that we've received is Grants Pass still considering purchasing land for an urban campground? So I think this is based on some previous work the council was doing to try to identify an urban campground site and work with a local nonprofit foundation to establish an urban campground / navigation center. This discussion was heavily utilized and discussed when we had some monies from the Department of Administrative Services. We had $1 million where we were looking at trying to earmark that for the purchase of land for an urban campground. Council at the time has utilized the majority of that money for On Track to help expand their services and provided 10 to 15 additional beds for drug addiction services and housing for the unhoused there. So currently right now, from a standpoint of the city purchasing property, there's not an identified revenue stream for that. So council has not taken that on as an additional discussion item. But part of that is not just because it's we don't have financial resources identified. The other part is there's actually a groundswelling of community support from a number of individuals who are making great strides in finding and coming up with a navigation center, which could be also some kind of campground facility or housing facility also. So there's some great things that are happening there, and it's happening from a community grassroots standpoint. And the city is participating in that process from council to staff. We're all part of that group also that meets and are making progress in making something like that happen. Is the city required to provide low barrier shelter?
No. So Martin v. Boise and the Blake and Johnson case make it clear that a city is not required to build or erect any sort of shelter, nor is it required to operate a shelter.
Thank you. So Karen, I know you've been filing back there all over the place, and do you have some questions lined up for us? And I'm afraid, I don't know if you got these set up here or.
Yeah, so these are like real outright questions. Some of these are a little bit more statements. So you can, this one is dealing with low barrier shelters.
All of these are questions in themselves. Okay, great. All right, I'm going to try to go through some of these. Thank you for those that had submitted things and also written them down. Some of them are relatively wordy, so it might take me a second because some of them are statements and a question is somewhere within the statement. So I'll start to go through these. First question, are the homeless allowed to have weapons such as guns, machetes, crossbows, knives while camping in our parks?
We're going to be addressing that on June 21st as well. There's a lot of things that I didn't mention just because I don't have the draft ordinance in front of me, and I've spent the last 3 weeks putting this together. There's a lot that we're going to be covering, and weapons is one of them.
So when you say addressing weapons, does that mean there is going to be some kind of conduct or something that would maybe disallow or would allow, or how does that?
So
what do you mean by addressing?
So it would disallow weapons in the park with an exception for people who have legal rights to carry certain concealed weapons, and it would also make sure that the police officers are able to use their weapons when they're discharging their duties if absolutely necessary. But it would be a prohibition with those exceptions.
Okay.
And there's state law too that will address that as well. Certain folks are and are not able to, but it's not to do with their classification of whether they're housed or unhoused.
Yeah, that's going to just be a general park rule.
Okay, thank you. Let's see, I got a statement here. Moving the homeless camp to the lot west of 6th Street. Does insurance cover all the homes there right now? Does insurance cover all the homeless there now? So do we have any kind of insurance coverage for individuals in the parks?
I have no idea. That's a good question.
I think at this point, it's recreational immunity being
Right.
utilized because we have not identified or designated a spot where they have to be.
Yeah, so the distinction is that you are not able to erect structures east of 6th Street. You are able to erect structures west of 6th Street. That's it. That's period the statement.
And then the other question follows along with the insurance thing also. Does the city insurance cover the park right now?
Like the city manager said, that's really under the guise of recreational immunity. It's another thing too, because we're following a federal court order. That's not something that can be held against us or should be held against us.
Okay, thank you. You know, this next question, this is a question I've asked myself as I've scratched my head. Is the court case being delayed on purpose?
So the Ninth Circuit is a very large circuit. I think, city manager said there are 11 judges. There are 26 judges. So, and the way that the judges are going to be picked are by lots. Is it being delayed on purpose? I couldn't tell you. What I can tell you is that the Ninth Circuit is an influential circuit. What happens here tends to reverberate across the country. That said, because it's the largest circuit, it's also the most overturned circuit. So another thing to keep in mind is that if there's a U.S. District Court case and somebody wants to appeal it, the Ninth Circuit is a appeal by right, so they hear all federal appeals that come to them. So it's kind of like the appeals court in Oregon. You know, you have the trial court, and then if you lose at the trial court, you can automatically appeal to the Oregon Court of Appeals, and they have to hear your appeal. They must hear it. So it's the same thing with the Ninth Circuit. That might be a reason why too, that it's taking so long. I couldn't tell you. This is snail pace for an en banc sort of decision. We've made that filing in November. It is now June. There's no reason it should have taken this long.
So a follow-up question to that from another individual is there a way to pressure the court system to act?
Unfortunately, no. The court system takes the time it takes. I've had to use this phrase a lot, being at the mercy of the court. I can't give you an explanation as to why the Ninth Circuit takes so long. I can't even give you a rational explanation as to why the regular court process in our circuit court takes so long if it's a civil case. It's just the way our justice system operates, and it's one of those things that, you know, I think courts are trying to figure out, but it's hard to answer that question. I don't think that there's any real pressure that you could put on a court to make a decision. It's not how it normally works.
And I think that whether or not the en banc gets granted, one way or the other, the court needs to weigh in on this matter. Because there's a lot of jurisdictions out there wondering, what do we do? And you might notice that this doesn't occur in other areas of the country, well, because other districts are in disagreement with the Ninth Circuit Court of Appeals. And when that happens, the Supreme Court tends to pick those type of cases up because there is differing points of view. So that might actually work in our favor.
Thank you. Another question how do we get the governor to come down for a discussion or get her to understand our dilemma and help us find a solution? I think one of the best ways to do that is for you to reach out to the governor, reach out to our representatives, have a discussion and let them know how House Bill 3124 and 3115 has been affecting our community. These are things that, as we stated earlier, we must make sure that our codes and the way we provide code changes and conduct is all in alignment with those federal state laws. So one of the best things I think you can do as an individual is to reach out to the state and express your concern and your desire for a solution. You guys have anything to add to that?
I think it's an appropriate time to comment on drug use in our community. Open air drug use is common. It was not common just a few years ago. So I know there are some bills, I'm not sure if it's a House bill or a Senate bill, and I don't know if it's tied up right now, where the reclassification of fentanyl to a misdemeanor is in the works, but I don't know if it's held up with the current state of affairs that's going on in Salem. But as I think happens quite often, we don't get the news until it's too late. And right now, like I had mentioned at the beginning, we're in crisis, and law enforcement, our department, we can't do anything about it. But we know if you're utilizing drugs in our park, there's needles all over our park, et cetera, et cetera. And I'm confident I heard recently that a kid was poked with a needle recently. We talk about this often. So these are the messages that we need to send, not to be disruptive, but to be providing the truth and to providing what's going on in our community that's having a solid impact on our livability, because our livability has diminished significantly, and it's because of ballot measure 110.
And I hate to be the pessimist in the room. The governor was the sponsor of both House Bill 3115 and 3124. So these were, when she was, I think she was the Senate, either the majority leader or the Senate president, I don't remember which, but she was the sponsor of both of those bills. The overlay of state laws complicated what we can do down here, and it has really neutered the police department's ability to effectively enforce conduct ordinances, especially those surrounding drugs. Even though there's currently nothing in our code that governs the use of drugs in our parks, it's a state violation. To me, it's still kind of crazy that it wasn't in our code, and that's something we're going to fix. But like the city manager said, it's incumbent upon the citizens, all of us included, to make sure that we're writing to our representatives, make sure that we're writing to the governor, make sure we're writing to her office to let them know what is happening down here. I sympathize with all of you in the sense that we've had this court case where we have a judge who has made a massive decision for our city, and we're having to live with those consequences. So it's one of those things you just kind of have to keep active, stay active with lobbying the state, because unless there's change in Salem, unless Salem hears us, it's going to be the status quo, and the status quo is not tenable.
And I would actually add, before the 72-hour requirement came in to notice campsites, the injunction as it was written was working. It was a 24-hour notice, and our CRT officers were able to effectively manage folks in the parks. It wasn't perfect, but it was a lot better than it is now.
Man, I am really, these questions are so informed questions. I love this.
Good.
So if the injunction is lifted, what changes would occur?
So if the injunction were to be magically lifted tomorrow, I mean, that really depends on the circumstances under the injunction. Did we win or did we lose? If we win, then not too much changes because of the changes in state law. The changes in state law are going to require the city to change its ordinances around camping, sleeping, and resting in public. Unless that law is changed, unless 3115 is changed, that will be the law of the land. If we were to lose, same thing. Same thing. We would be basically in the same boat that we're in right now, with the exception of drafting time, place, and manner regulations for where homeless individuals can sleep and rest in public places. It's really, but the consequence of losing is more than that. It's going to reverberate across the country. Other cities like ours that are our size with our resources, look at where we are on the highway. We're right up and down, right next to I-5, easy access. Other cities like ours are going to suffer the same way that we are currently suffering if we lose this case. It's going to be very difficult. But if you win the case, then you're able to make a better case that, hey, maybe 3115, in terms of making these time, place, and manner regulations, it isn't something that we need. But again, that's kind of looking into a crystal ball. But the fact is, 3115 is going to be the law of the land, and we're going to be expected to follow it as a local municipality.
Thank you. Another question, what resources do we have to help the homeless if a fire happens like in Talent? I guess maybe I can take that one, or the chief.
Yeah, I can get it started. You know, we're not a big city. We don't have a ton of resources, but I think when crisis happens, we come together and we work really well together. It's going to be an all hands on deck. The Open Chain fire recently that impacted us a couple years ago, we immediately activated a call center and just went to work. And that's what will happen. Churches come together, community comes together, schools come together, Gospel Rescue Mission comes together, Red Cross comes together, United Way comes together. We all come together when that happens. I hope that we don't have any major fires again, especially this year. But we work really well together in crisis. It's unfortunate. That's what we do. We live in crisis. We were actually communicating about a crisis that was ongoing just a few minutes ago. But that's what we will do, and we will treat everybody equally and get them help.
We specifically also, we have, there's going to be multiple people if we had a fire like that are now considered unhoused, and everyone would be treated equally.
Yeah. We actually, when the big fires were out in Cave Junction area, we had a lot of folks that were setting up at our schools and, you know, temporarily, but, you know, FEMA and a lot of other agencies would come in and assist.
This is an interesting question. Fentanyl, of course, we've heard small little doses can do all sorts of damage. Is there concerns with fentanyl maybe being dropped into the river? And do we have a plan if something like that happened?
I'm not concerned about fentanyl being dropped into the river. I'm concerned about fentanyl in your lap. I'm concerned about fentanyl in front of a child. I'm concerned about fentanyl and me and our officers. Because for those of us that aren't used to using fentanyl, you could die immediately. I would recommend that most people nowadays actually carry Narcan. I, in fact, recommended to my own spouse to carry Narcan because she's around young people all the time. You never know. But fentanyl will be diluted and not impact anybody in small amounts in our rivers. But for you and I, it can be lethal.
Okay, thank you. Got one here. Well, it's more of a statement. Augustus is awesome. GP is lucky to have him with a heart. So I think I'll give that to Augustus.
Oh, thank you. I appreciate that.
That's from Karen.
Okay, I wrote that myself. No, I'm just joking.
Yeah, before you guys came in, yeah. No.
So the next question is from for our shelters, the few that we have, like the mission. Is there room in the current shelters?
I can hit on that. The Gospel Rescue Mission, from what I hear, there's always room. Those numbers vary, obviously, from 20 to 50, I think, and they have different sections for male and female. The Ramsey property, I believe, is always full, and there's a wait list. And our Foundry Village project was a mad success. It's super successful, and I believe there's a waiting list there too. And I don't think there's any others. That's it. And we do open the emergency warming shelter, and that usually houses, I think the average numbers might be in the 50s. But, you know, teams come together and they manage that overnight or sometimes 24 hours, depending on the conditions. But that's it in GP.
Thank you. Great. And these are great questions. Are there certain public space violations that are not being prosecuted by our DA?
I'm going to touch on this one a little bit and just share with everybody. Our DA is overwhelmed. He needs more attorneys. There's not enough to go around over there. Their caseload from a felony caseload is massive. Our attorneys here could run circles around attorneys anywhere in the United States because they have a significant amount of experience with major crime. I am super proud of Josh Eastman and his team because they work so stinking hard. And do they sometimes not prosecute lower level cases? Absolutely. And that's called prosecutorial discretion. And I do support that because they have to prioritize their workload too. And it's huge. Todd?
Well, they're not alone either. The shortage of prosecutors now is a big deal. And actually for defense attorneys as well, they're having a hard time. So the quagmire that can go through our criminal courts is not unlike the Supreme or the district courts.
So the next question is, what are the ramifications if we basically just drop the mic to the federal injunction?
As in, ignored it?
Yep, just did our own thing.
So if we were to just, let me start by saying this. I think that everybody in this room believes that this is a country that's run by the rule of law, right? We are a country of laws. When we start to get into that area of violating a federal court order, we get into very dangerous territory, not just as a local community, but as a country as a whole, right? An exercise I like to do is, all right, if I want to do something, I want to imagine my biggest political adversary who disagrees with me on everything. What if they had that power, right? If that power upsets the balance of our constitutional republic, probably don't want to have that happening. So the consequences for violating a federal court order are similar to those for violating a regular court order. You'd be held in contempt of court. That comes with accrual of fees, probably on a daily basis. Another potential issue that might be kind of ancillary to this would be that the federal government would know that the city of Grants Pass is violated and is willfully violating a federal order of the court. That might have ramifications for us in terms of federal funding, getting federal grants, and it's not something that we're prepared to do. That is not in the best interests of the community. That's not in the best interests of our taxpayers. And so, in remembering that we are a country of laws, that we are governed by the rule of law, it is important to, even if we disagree with the court's opinion, there are mechanisms to go about disagreeing and trying to get something overturned. It's important that we don't lose our way in keeping to those principles. They're very important, and it's the foundation of our republic. It's not something that we should just be so readily willing to throw away. I know it's frustrating. I know it all takes time, but it's not something that would be in the best interest of the city.
And for your police department, what that means is a federal consent decree where they come in and say, we're now running your police department because you're willfully violating people's civil rights. And so as much as you like to visit Warren in his office, that would probably not exist anymore.
Yeah, we also put our team at risk. We have to look out for the men and women that work here, and that would put them in a bad space. We don't want our officers to be sued, and that will happen. That would happen.
So homeless camps pop up in vacant lots near my neighborhood. can I call the police and ask them to be moved, or does it require the landowner?
Landowner would have to do that. That doesn't mean that we can't research who owns it and ask them if that individual is consenting to that person being there. You can also go online and fill out a trespass letter, and so if we have that on file, we can trespass people in your absence.
Call us if that happens.
Yeah.
Thank you. I'm just going to acknowledge the question, even though it's one that we really can't address on this one, but why is Josephine County not filing a state of emergency in order to receive federal funds from and also state funds? And that's a Board of Commissioner question.
I agree with that.
Another question, where are our rights as property owners to feel safe, Morrison Park in particular?
So that's fantastic and cogent question. Morrison Park in particular is surrounded by residential areas. There's townhouses to the east, residential properties to the south, and an apartment complex to the west. Your property rights are of paramount importance. Just because individuals are able to sleep and rest in the parks does not mean that they're entitled to be bad neighbors. That is what we're trying to address in terms of our conduct and nuisance ordinance. We are trying to protect individuals who live near parks as well as the people who frequent them. And so that is a major consideration in terms of what we've been trying to craft to bring to council that does strike that balance of letting people know, yes, you might be able to sleep here because of a federal court injunction, but you have to be a good neighbor or you'll have to go somewhere else. That's what it is. It's conduct that we really want to emphasize. So we fully recognize your rights to your property, and we fully recognize the privilege of using the park. We want to try to make it so that conduct is punished immediately when it's found.
Thank you. Just as a heads up, and I'm willing to stay here all night, but just as I've got about 35 more questions. So.
Bring it on.
Okay.
Bring it on.
You bet. I just wanted to make sure from a response perspective. State-created danger could be imposed to the community at large by creating a low barrier area for camping. Will the council consider this state-created danger both ways?
Could you repeat that question? Sorry.
So I think the question comes at the heart of, if we designated a camp, there is a potential state-created danger, but just having the unhoused in the park, is that a state-created danger?
I see. So I think the distinction there comes with the fact that we're following a federal court injunction. So there's a difference between affirmatively saying, this is where you need to be, versus having a court, an outside entity, tell the city, this is where you need to allow people to be, right? But the state-created danger aspect comes in when you are saying, this is where you have to be, period, and we're just gonna put a bunch of people there, low barrier, whatever happens, happens, right? Whereas the federal court injunction just blanketly says, we have to allow sleeping and resting in parks during particular hours. So the analysis isn't exactly the same, because the city wouldn't be affirmatively saying this is where you need to be. The federal court is telling us where where homeless individuals are supposed to be. That's the distinction.
Okay. Let's see. Question. Does the warm and dry aspect of the Ninth's ruling give license to occupy or use private property? And it may mean public property, but maybe both private or public.
So if it's private property, I don't think that that's the case. I think that we have come across this issue already. And the advice that we gave was to call the police, was to call law enforcement. Private property is not going to be subject to the 72-hour limitation. Now, if it is on public property, that's a different story. it'll be subject to that 72-hour posting. And like Chief Hensman and Captain Moran have been saying, Artoff and McGinnis have been out and about every single day, and they are on top of it, but they are only 2 people. So, but they are out there, and they're out there making sure that public property is, that camping on public property is posted, and they're making sure that if people are there, they're following rules, and that they're leaving when they're supposed to leave, and they're going other places when they've been in one place for too long, or that they're following conduct rules, basic conduct rules like picking up your trash, not drinking in parks, not doing drugs, things of that nature.
Okay. The next question, how often are Class E and Class A violations issued? How many Class E violations result in assessments as opposed to fines?
I'm not sure who wrote that question clearly, but I'm wondering if that has to do with the ballot measure 110 question and case screenings.
It is to measure 110, yes.
Okay, I don't have the number off the top of my head. I know it's a small number of folks that are screened, but also too, I believe the judicial system changed the maximum fine from $100 to $40, and that happened, I think, in 2021, I think. But essentially, the amount of people paying those fines are low. So I think that answered your question.
Okay. Another question, does more strict enforcement of drug offenses jeopardize the city's position with respect to the injunction?
No.
Okay. From a standpoint of the injunction, the city's stance on the reading of the injunction, are there opportunities to propose an interim management plan to the courts while waiting for judgments?
Honestly, that'd be a better question for the outside litigation counsel. My take is it probably wouldn't change much on the ground in terms of police activity and enforcement. I don't think that it would really change too much, but I think that also that might be a better question for our litigation counsel. That's something that we might look into and get back to you on.
Okay, thank you. Another question for the city manager, do you feel this issue is affecting downtown businesses? And I think you guys can also weigh in if you so desire, but yeah, I think this issue is affecting everyone. It's affecting everyone in the nation, in Oregon, here locally. It does have an effect. And that's why we're all here together, hopefully as a team, trying to come up with some solutions on how we can minimize any negative impacts and then focus on the positives.
We've been in problem-solving mode for quite a while for those folks that have been here for a number of years. If you remember back when St. Vincent de Paul was, serving food down by the bank on 7th Street, and we partnered with St. Vincent de Paul and some other folks to get a mobile kitchen. And so that took that pressure away from the downtown. It was pretty successful. And the other thing that we helped with was at the sobering center. And I don't know how we would survive now without the sobering center. Before we had nowhere to take anybody except for the hospital, and they were not happy to see us that many times a day. So there have been some real success stories of private partnerships with public entities, and we're real proud of those, and it's taken a lot of heat off the downtown and made them more successful, in my opinion.
Just another comment on that too. There was an earlier question about sidewalks and walkways downtown. That's an ORS violation, disorderly conduct, and we've managed that for years. Some cities across the Ninth Circuit choose to manage those laws differently, but we don't. So we regularly deal with that and take action accordingly. But also too, as a reminder, our community response team was originally designed to be a downtown entity. 2 officers downtown patrolling the CBD, the Central Business District. That's flip-flopped. They have to be in the parks pretty much all the time right now. So we don't have enough officers to replace that role. Now, our on-duty folks, they do supplement that when they have spare time. But also, too, because of shortages and because of training requirements for law enforcement and putting people through the process, we're suffering from shortages right now. it's not uncommon to see traffic zooming up and down 6th and 7th Street. And we don't have a traffic team currently, so we're trying to problem solve that as well as everything else. So our hands are full, and I just saw an opportunity to share that with you all.
I think this question is just born out of some frustration also about the court's decisions and things, but when do citizen rights count? And I think from a standpoint of whatever it's a federal ruling, state ruling, or even local ruling, the fact is people are trying to make sure that citizens' rights count, and that is of all citizens. And some of those rulings people may agree or disagree with, but at the heart of it is trying to make sure that there's fair and equitable and dignity associated with all citizens.
Yeah, we live in this community with you guys. We have to go through the same things that you guys are going through. I gotta say, like, as a citizen, I feel you guys, I really do. In living in this community with you and getting to know you people and getting to form relationships with a lot of you, it's very clear that you're passionate and you care about the city and you care about human beings, right? I think that that's completely clear. It's a really hard situation when you have a court that seems so far away making a huge decision for a community like ours. It is very difficult, and I share in that frustration. Unfortunately, that's the reality of our legal system in the United States. It's one of those things that, for better or for worse, it's going to stick with us.
Next question is, why are we not banishing weapons openly in the parks and not citing or arresting?
I can take that. I'm not sure where that comes from. If we have an opportunity to arrest somebody for a crime, especially a weapons crime, we do so. However, if you're not a felon and unhoused, you can legally have a gun. So, equal rights across the board. Concealed weapons are different. Dangerous weapons can be different depending on how it's utilized. But essentially, we take all weapons offenses incredibly serious, and we act accordingly. But just as a reminder, everybody has a Second Amendment right as long as you're not a felon.
So another question. In general, the situation, what is the best way to handle something when you see someone that is weaponized near your home, and say the individual is alone and the husband or wife is at work? Should this be considered a life-threatening thing, and what does the PD suggest?
I'll kick it off, and I'm sure Todd will jump in here with me. We all perceive violence differently. We all perceive crisis differently. We all perceive threats differently. Do not think for a minute that you have to think about it. If you think your life is threatened, please call. If you think it's a 911 call, you call 911. That's really what I have to say about that. I would perceive things probably a little bit differently, but if there's someone lurking around my home and he's brandishing a machete, I would be calling the police. So maybe, Todd, do you have anything to add?
Yeah, kind of what I said earlier, an emergency is really defined by you. It wasn't too many years ago where during September, and some of you might pick up on where this is going, but there was an individual living near the Grants Pass High School that was carting a lot of long rifles in and out of his house, and that solicited a call to Grants Pass Police Department saying that there was someone walking towards the high school with rifles. Of course, we respond immediately to something like that. Of course, it's September. That guy's going deer hunting. But, you know, you don't know in the moment what it could be, so I would encourage you to call. And, you know, safety is always within your home, because that shows an intent if someone is actually trying to get into your home, and just staying on the phone with our 911 dispatchers, and we'll get there pretty quick.
This is for police likely. Earlier, you guys mentioned, I think Chief Hensman, you mentioned ODs.
I did.
Of the ODs, is there a number that can be attributed to those that were unhoused?
Probably. I don't have that at the ready. We recently lost our criminal analyst, and we're not replacing that person because of budget issues. So finding data isn't as easy as it used to be for me, but I can get that number. I've actually discussed with our kind of part-time PIO that we have on the team, how can we share this with our community? Because I think everybody needs to know via some sort of a police media platform like Facebook or a flash alert or something like that. And I don't think it's appropriate to put out a notice to the community to say, hey, 11 people died from an overdose and 6 were unhoused. I don't think that's appropriate. They're all people that have passed away and they all have a story. So that kind of is a tough one. I could find the number, and if you wanted to come and meet with me someday and talk about it, I'd probably share it with you. But I don't think I'll make that public.
Like you said, anecdotally, though, in the parks, it's a regular occurrence, more so than other locations.
So this question pertains to what's observed in other states, say, for instance, Florida. If all states have to abide by federal law, why are some states not experiencing the homeless problem like we are?
So that is a question that really gets to the heart of the way our appeals courts work and Article 3 courts across the country. So there's Article 3 courts authorized under the Constitution that are basically district courts for different states. Think of those as a bigger version of like the Josephine County Circuit Court or the Jackson County Circuit Court. These Article 3 courts are organized into the circuits that we hear about all the time. We're in the 9th Circuit, Colorado, Wyoming, Utah in the 10th Circuit, and they operate in that way. So each circuit has its own set of laws. Sometimes those laws are consistent, sometimes those laws conflict, and if there's a serious enough conflict, that's where you see a lot of litigation that ends up going before the Supreme Court. So what happens in the 9th Circuit doesn't necessarily immediately affect what happens in Florida or what happens in the circuit that Florida is in escapes me. But it doesn't necessarily bear on that circuit. Now, as Captain Moran very articulately pointed out, there are serious enough inconsistencies sometimes in law, in the same area of law, where there is one circuit that says one thing, and then another circuit that says another, and then sometimes a third circuit saying something else. At that point, there's what's called a circuit split, and that makes it a little bit, that gives the Supreme Court an excuse, really, to look at that area of law and make a final determination. So where I said that the 9th Circuit and the other federal circuit courts, the federal appeals courts, they have to hear all of the appeals that come through to them lawfully, the Supreme Court can pick and choose their cases that they hear. So the Supreme Court is more likely to choose a case to hear if there's a circuit split. So there is absolutely a possibility that the 9th Circuit might say one thing and then another circuit might say another. And it might be that it's serious enough that the Supreme Court has to weigh in. So all of that said, what happens in one circuit doesn't necessarily affect the other. Not always.
So the next question is, what's to stop the homeless from coming back after Riverside Park is open? And ultimately, that's not the intent. The intent of the closure of Riverside Park was due to safety concerns, and we had to shut that down because of that. And there was a specific and purposeful time on when it was going to be reopened, and that's June 22nd. That's the day after City Council adopts new code changes that will deal with additional time, place, manner, and conduct in the parks, which will provide additional tools for our police department. Where did the questions from the pre-printed sheet come from? Oh, those questions came from questions that have been asked. The sheet that we read up here, those are questions that were asked at city council meetings and or submitted in advance of this to Karen through email. What work is the city of Grants Pass doing to get feedback and participation from homeless people in addressing these issues?
As far as feedback within your police department, we have a software product in place that sends any complainant or victim a text message to solicit feedback. So if there's an unhoused homeless person that is in one of those situations where they're a complainant and or a victim, they too will receive those messaging. We take customer service. We believe it's incredibly important to our mission, and it also fits into our philosophy. But I think that question really is baked in. Where do unhoused people share their concerns, and how are their voices being heard? But to answer that particular piece, I'm going to jump it over to Captain Moran here in a minute, because Todd has partnered with PATH and Mint, two community organizations, and we've met with them before. So maybe I'll throw it over to you, and it's a good opportunity to share what your police department does regarding outreach and building trust with community.
And Julie's here tonight with PATH, so she can attest to some of this. We met with PATH and Mint a couple months ago about what their mission was with the unhoused, and tried to see where we could partner with them in doing certain things. In regards to more direct contact with the unhoused and kind of getting their feedback, it kind of goes back to our community response team. They're in continual contact with UCAN. Anytime we post a tent, we dictate on a email back to UCAN every day where the tent is, who belongs to, or if we're not able to identify who it belongs to, and that the fact that it was tagged for 72 hours. So working close not only with CRT, but Lieutenant Minor sits on advisory type of position. He just attended a meeting yesterday with UCAN to try to get any feedback from them that where we can be a part of the solution also. So it's a kind of a continual thing.
Okay. Next question, it deals with housing. Why does the city seem so reluctant to incentivize building more apartments, affordable housing, tiny homes? Other communities are similar sized. They're prioritizing this to improve housing issues. We have a very active housing advisory committee who's made a lot of great recommendations to council. Council has implemented a number of new policies in the past 2 years that are associated with freeing up regulations with affordable housing, incentivizing density levels. And we recently adopted a housing production strategy, which has some of those things and future recommendations for us to strive for. That, I believe, is online, and that's a great resource for taking a look at what we're doing and what we're looking at doing. But we are very proactive in looking at getting out of the way, trying to reduce regulations associated with density levels and affordable housing. What is being done about the hard drugs being shipped into the city?
There's a tough question. You may not know this, but we have a rogue area drug enforcement team that we're super proud of. And I heard today that the team recovered, I think, a pound of cocaine. I think they're busy. They don't check in with me all the time, but they're busy. And they're actively trying to thwart the transportation of illegal substances up and down the I-5 corridor and coming into Grants Pass. There was a time, I remember when I first got here, I'm going to look to my left for a little feedback from Todd, but to show you how productive our drug enforcement team were and will be again, the community that utilized drugs knew, don't go to Grants Pass. You're going to get caught if you go to Grants Pass. You're going to go to jail. And the price was higher in Grants Pass because of the threat. So am I hitting that right, Todd?
Yeah, so we partner with the Oregon State Police, Community Corrections, and the District Attorney's Office. That's the members of RAID. Just the other day, we served a search warrant about a quarter mile up the street on Washington Boulevard. You guys probably saw that. So that was a direct link to fentanyl. And so we're happy to welcome Oregon State Police back to the team. They had taken a short hiatus and they're back in with us. And so we're also part of the high-intensity drug trafficking area. We receive federal money from the federal government to do that type of work, not just inside Grants Pass. I'm proud to say that RAID was responsible for taking off several drug trafficking organizations that led all the way down into Mexico. So it's not just little places like Grants Pass, it's big.
Yeah, and one more piece, because as we get flowing, we recognize how, for a small agency, how big we are and what we do. We also have a team member assigned to the DEA who is incredibly productive, which means we have the full strength of the DEA in little old Grants Pass. So we need to get the biggest bang for our buck to thwart problems in our community, and that partnership with the DEA is outstanding.
The next question is, are we committed to supporting the police and enforcing the ordinances that can help improve the safety and security of our parks, downtown, and community? I'd have to say yes, we are, from council as the policymakers to staff to the creative solutions that Augustus has come up with that we're bringing forward to council for the June 21st meeting. We are a great team. We have a great team of individuals. We have something in Grants Pass that no one else has. And you're looking at them along with all my other colleagues. And that is a really strong team. And I'm proud to say that I work with them and we do some great things. So. Medford has $8 million to address homeless. Why can't we assist redirecting our unhoused to services in Medford?
So this kind of goes back to the question about why not just give people a bus ticket? Why not just ship them out of town? You're unfairly shifting the burden from one community to another. You're not solving the problem's not being solved from just any sort of perspective. So part of that has to do with possibly some of the state funding that came down at the beginning of Governor Kotek's administration. For some inexplicable reason, Josephine County was not included in that. That's a question for the commissioners in terms of applying for the emergency declaration. That's their decision. But it's shifting the burden from one community to another. You're not solving a problem. You're not helping anybody get out of homelessness. If people decide, hey, that's where the services are and they go, that's where they go. And you probably do see that in some circumstances. But I don't believe it's the government's place to say you need to go to this place because we don't have service. It's just not something that's tenable.
One of the things that we do, and I think Todd mentioned this at the beginning, our community response team and our officers that have the ability to work with our case manager, that's our team member from Options for Southern Oregon. They collaborate and they find out who has an open bed, who has a facility, and that could be in K Falls, it could be in Douglas County, it could be in Medford. So we do work with each other that way, kind of utilizing each other's kind of continuum of care. But that's something that we do, but we're not going to be that department that puts somebody on a bus to Medford.
Another question, what is the protocol if you get stuck with a needle if you're recreating in the park?
Yeah, that's an emergency response call. It's going to be an EMS call. Yeah, I don't know if you have a tetanus shot or you might need one, but anything else to add there?
Oh, just, our officers often experience this very thing. It's one of the hazards of our profession. So, there's some nasty drugs that you end up have to take, to try to kill anything that might be present. If you're lucky, you might get a cooperative individual that says, here's what I have and here's what you should probably ward off against. And then, you have to, get kind of a baseline blood draw, so then you can, for the next 6-8 months to a year, get continual blood draws and try to figure out if anything made its way in. So it's not pleasant.
Another question is, can we get a tax credit for the sites we can't use? I'll take that one. Yeah, there isn't any credits actually being created. The parks are still available to be used. Riverside Park is actually closed, like I said, for a couple more weeks, but the work is still happening there. We're doing a lot of maintenance and upkeep and looking very forward to the way the park will look come June 22nd when everything is open. Why are people who are overdosing in our parks not being arrested for drug use?
We can't. That's why. And our priority when someone's overdosing in the park is their health, and we got to get them into a facility. We're not going to follow behind them and arrest them when they're released from the hospital. There's also I think there's some recent law that prohibits us from doing that anyway.
Yeah, it's a state law. You can't arrest somebody for that.
But fundamentally, we weren't doing that anyway, and I don't think anybody was doing that anyway. Somebody's health comes first, and then we're going to take an opportunity to engage you with some kind of encouragement to seek some services. And frankly, sometimes we annoy the heck out of people, but it's our job to annoy you enough to say, okay, I'm sick of you, I'm going to go see somebody. We do that because we care, and we'll take an opportunity to try to engage somebody into a service, into some kind of treatment, but we're not going to arrest somebody after they've just overdosed.
Another question is a question for doctor, not for us. Enforce resting hours, not the 72 hours, the Medford rule. So that's a good one. Now, we've heard Medford passed this rule where they only have to provide 24 hours notice, not 72. You want to address that?
Yeah,
Oh, and before you, we're down to, I think, 6 questions. So just to give you a standpoint, so hang in there.
Yeah, no, we really do appreciate this. Thank you. So Medford is, they're in the throes of putting into place their own time, place, and manner regulations for the use of their public property for sleeping and resting. So essentially, a camp will have to be there for 5 days before it be considered established. Now, once it becomes established, then the 72-hour rule is in effect. So I was just going to say something. Oh, so the state law itself doesn't define what an established campground means. I had to have been on purpose. I looked at that and it hurt my lawyer heart because it was just so vague and it's so open to interpretation. We will be watching whether this works out for Medford very closely. Without revealing too much, I have talked to some of the lawyers there. They are waiting to see what's going to happen, and so are we. Right now, we are in a different legal landscape than Medford is. We are in the throes of a federal court injunction, so we are in the middle of an appeal. So it's important that for the sake of litigation, we don't make any changes that affect sleeping or resting. That is our camping ordinances and sleeping and resting ordinances that are the subject of this appeal. While we are in the middle of doing it, we don't want to do anything to change that so we don't moot our case. But we are watching what is happening with Medford, and so is our outside counsel. So we are in constant communication with them about we're in constant communication with our outside litigation counsel about what we can do as much as we can. All the time, how far we can go while staying within the spirit and the word of the injunction. So we'll be watching that very closely, but it's right now not a risk that we should be taking from a legal perspective.
All right, another question. All right, take a deep breath. Any consideration for the Texas property located behind Parkway Fire Station to be an urban campground? So that's got a lot, that property itself, although it looks big and vast, the large portion of that property is actually in waterway, wetland areas, and that would be definitely a state-created danger where we could not place individuals in the floodway or the floodplain. And so that provides just a small little spot more towards up the top. And it goes back to some of the questions with regards before about does the city and is the city willing to establish a location? Another question is just a question, is there a difference between an urban campground and insurance coverage and a navigation center that's run? And the question is, why is one covered by insurance and one not covered by insurance?
That's a good question, and that's something that I think we don't have an answer for that right now, to be honest. A navigation center is a little bit less of a risk because you're going to be having professional individuals, professional groups running the operations for something like that. And they're going to have insurance that will cover those operations. An urban campground is something that is a little bit more untested. It's hard to give an answer to that, but an urban campground is different from a navigation center in that a navigation center sometimes involves actual shelter space with actual beds where people stay and then they receive services or get pointed to other services. Whereas an urban campground is just that, a place for you to pitch a tent to rest and sleep, not necessarily providing a step out of homelessness. So not to say that urban campgrounds wouldn't have rules or that, again, professional organizations wouldn't be running it, and they would have insurance too. That's probably why we're wanting to create separation. You know, council had wanted to facilitate, use that word again, facilitate an urban campground, but the city would have been completely out of it. So that was something that was considered at a time, but there might be a difference. It's hard to give you a straight black and white answer for that.
In our discussions with other service providers and those within the state of Oregon, I think Augustus has it nailed pretty well. An urban campground or something that it would be facilitated and organized by a nonprofit. And in either situation, it'd likely be a nonprofit, not the city, so the city's insurance wouldn't come into play. You have a more likely chance of having it covered by insurance because it's managed versus an urban campground, which has a little less management associated with it when you just look at the definitions of those things. And that's why a lot of service providers now are looking at more of the managed navigation center type of sheltered facilities, not just an open urban campground. Are we using tax dollars to pay the unhoused to leave? The answer would be no. Who are responsible for the cleanups? So some of the, I think this question is centered around who's responsible for cleaning up areas that may be on private property that have been left by the unhoused or left behind.
Everybody was jumping on this one, I can tell.
That is a
Yeah.
very thoughtful question. So the question, as I understand it, is that an individual is camped on private property and left a mess. Would it be the private property owner's responsibility to clean it? From a legal perspective, probably. It depends. That's a very difficult question to answer, but I think that you're trending toward. Yeah.
And I would throw in there too, I'd argue the fact that you've got the crime of criminal mischief and you could seek
Civil damages.
Later on down the road, but that's a lot of work. I think ultimately it probably is on the homeowner, it's Mike Ray shaking his head out there, yeah. And then obviously public property is on the city.
I think Christine Locke's group, she's a member of PATH, has done some private property cleanup And I don't know if there was any payment for that or not, but she's been working with private property owners to get things cleaned up.
What about all this screaming and fighting? What should we do if there's continual screaming and fighting that you're witnessing or realizing?
Yeah, screaming and fighting, it's disorderly conduct, it's a crime. It's, violent, tumultuous behavior that's makes other people feel in fear. So you've got either a crime or you've got a municipal code violation, you should call the police. And also, too, I would just throw out there that we have a major problem with domestic violence in our city and across the United States. And if you see a couple people screaming at each other that look like they might be in a domestic relationship, please call us, because the last thing we want is a domestic homicide on our hands.
All right. Got a couple other questions here. We're getting down to, I think I've got 3 or 4. Is the city amicable to allowing low-barrier shelters and/or campgrounds within the city limits? So the answer would be yes. We currently, and the reason why I can say yes is it's technically not a policy decision. It's not something, it's already allowed. You'd be looking at it from a zoning perspective. Does the city have zoning codes that would allow a shelter to occur in the city? And the answer is yes. They would be allowed in industrial, business park, and the commercial district. Would the city consider changing zoning status in part of the city if necessary to accommodate a low barrier shelter or campground? That is a little more complex in nature because there could be situations where you couldn't change the zone to the zone that would allow it if you found a piece of property that would work. And then ultimately that would be also a policy decision by council that would need to be identified by council. Or it would need to be a charge that was taken by a nonprofit or a private individual that was wanting to place that type of use on that property. If a nonprofit finds a property within the city limits on which they would like to establish and operate low barrier campground or shelter that is acceptable for such use by the surrounding community, if the property is within 1,500 feet of water and sewer hookup, would the city be willing to extend water and sewer hookups to the property? That is definitely a council question. So if something like that is identified, or if someone has, these are very specific targeted questions, probably a good idea is whoever wrote these questions to contact me, and I can give you some more direction on how to get that process started if you so desired. What are the chances of using the parking lot around the Flying Lark as a low-barrier campground? I don't know what that zone is. I don't think that zone is allowed for, it's not allowed for that use.
I don't think so
It's
either.
not one of the 3 zones that I mentioned.
I don't think so.
Great questions.
That is a good question.
Let's see. Campers move but leave their trash. Can we make them clean up?
You can ask them to clean up, but I can't make anybody do anything they don't want to do. But what I can do is if they refuse, then they have broken the law and I can take them to jail.
Another question is pertaining to, this is specific to Gilbert Creek Park. My son used to play there all the time when he was in high school, so the same with my daughter. Can we clean up Gilbert Creek parking lot for weekend tennis tournaments? And I think cleaning up, I think it's probably alleviating and creating some space for parking and other things, because the parks crew themselves will clean up litter and other things because it is one of the city parks that we maintain.
I will add to that, one of the jobs of our community response team, and just purely by happenstance and because of the interactions they have with people daily, they have a relationship with a lot of folks in the community, both housed and unhoused. And it's not uncommon for them to share some community concerns, especially if there's a sporting event happening. You know, hey guys, is there any way that you might be able to encourage some of your friends and some of the people that you sleep with, rest with, to maybe vacate for a little bit? There's conversation that happens all the time. It's absolutely okay for us to converse with people and just share that you may intimidate other people unintentionally because they don't know anything about you, or because some people might be in the throes of addiction and they're super unpredictable. But my point to all this is Jason and Tim, they converse, they chat, they communicate, they have relationships, and they've actually done a whole lot of things behind the scenes that nobody ever knows about, and nobody needs to know about it. It's just called being a community police officer, and that's what we do all the time. And now it just might have to be a conversation with somebody that's unhoused. So the cooperation between people, it's actually pretty good. But then there's plenty of people that do not cooperate, and that's why we're here tonight.
Got 2 questions left. One question is, who pays for the ongoing operation costs of a shelter once it's established? So that's a great question that really has multiple answers. It depends on the community. Sometimes some cities help support the ongoing operations of an urban campground and navigation center. Sometimes it's nonprofits like UCAN that help provide that and get additional federal dollars to operate, or state dollars to operate a shelter. Sometimes it's multiple community partners. It is very unique to each community on how that's funded. And the last question is one that seems like I would even throw out there at the end. This is a great one, and I saved this one for very last. My question is, I mean, this is not my question. This is someone's question. Oh, it does say my question. My question is, what can we as citizens do? How could we help as opposed to escalate? Love these questions. That is just awesome. Yeah. So I'll take it, and the panel, please take on. Exactly what you're doing tonight is an amazing effort at showing you want to be an active participant in creating a true solution to this issue. This is huge, because you're going to walk away from this knowing the exact foundational barriers that we're working with. And with that knowledge, we can now start talking about creative solutions, because that's what it's going to take. No one in this nation has figured this out. So what we can do is we can start to try to look at how we can turn the tide and make a difference in this situation. So, and this is the first step.
What I would say to the citizens is to utilize the parks. Be there. Be out there all the time. Enjoy them. Recreate in them. When an area falls into disrepair, it remains in disrepair. And when people don't go, it falls into disrepair. But when you go to an area, when you shine a light on an area, it will only get stronger, it will only get better. We fully understand, again, your feelings about the parks and we fully know what's going on out there, and we're doing our best to try to fix it for everybody. But my hope is that the citizens will utilize the parks and stay out there, and to not to surrender it, go out there and use them. And we will do everything to the best of our ability to make sure that citizens are safe, and to make sure that there's equal applicability of our laws to everybody, because ultimately it keeps everybody safe. These are not targeted at homeless people. This is for everybody. Somebody who's staying in the park can use that ordinance to protect themselves if they see somebody is doing something that they're not supposed to be doing. But my biggest thing for all of you is I would implore you to use the parks. Continue to be in those spaces.
I echo what my colleagues said, but also too, I think it's important for the community to be involved in lots of ways, and that's understanding the resources you actually have within your police department. It's very limited. When I first got here, for example, I was assigned 58 sworn police officers. Rolling into fiscal '24, I'm only assigned 56.5 police officers. That's a reduction. And we had plenty of crime and plenty of work in 2019. We have the same amount in 2023, plus what we're dealing with in the parks. The men and women of my organization are exhausted, and we don't see a light at the end of the tunnel. But you have some incredibly dedicated men and women that believe in service, and they put themselves first. Put you first is what I meant to say. They put themselves second. That is the philosophy. We're struggling with hiring good men and women to be police officers. You can help me by encouraging people to apply to be cops, dispatchers, community service officers, cadets, and help shine a light on the work that we do, and that it's not a scary place, because sometimes this uniform is a bit of a barrier, and we kind of got to get past the barrier of the police uniform. But I think that's important for you all to know, that we struggle. So although currently we have assigned 57 sworn police officers, the amount of people that are actually out on the street providing the service, working patrol, is not anywhere close to that. We have vacancies, we have people on protected leave, we have people on light duty, and there's only so many of us to go around. And in fact, today, one of my teammates shared that this person's going to move on someplace else. So just staying kind of educated with what we have to deal with in the police department would be kind of my ask to you, as well as everything else that's going on. And I don't want to be selfish, because there's so many other departments around, to include our colleagues at the fire department, for example, within the public safety sphere. But it's important to kind of know that too. This week, I think we answered approximately 1,350 calls for service. So when you divide that among about 40-ish people that are out there working, and that too includes our CSOs as well that are put into that, our folks are answering a lot of calls for service every single day. And then sometimes we forget we got to write reports on everything we do. And in fairness, a lot of those reports are really quick. A lot of those contacts might be traffic, might be a person contact, but there's a lot going on. Our Citizen Police Academy is getting ready to ramp up again. Please put in for it. It's a wonderful course. It goes on for several weeks, and you get to meet all the team. And it's kind of cool to be involved that way. But it also, I need ambassadors to share our message too. And we're all ambassadors to the city of Grants Pass. And we just need all the help we can get. And we're understaffed and we could use more, but there's only so much money to go around. So I just wanted to share that. It was an opportunity. And that's what I would have to say about that.
So I just wanted to thank everybody for coming out tonight. I think what you're doing right now is one of the biggest things you can do for us, is just get informed. One of my pet peeves is to hear that, yeah, I called the police and they didn't do anything. I think that finding out that there's a lot of things in play that limit what is able to be done, and then, like the chief said, passing that on to your friends, your family, saying that there's a lot of reasons that go behind what you perceive as nothing. And just know that those men and women out there protecting you get frustrated too. And they want to do everything they can for you, and sometimes they're just not able to. So thank you for coming out. I really do appreciate it.
And I just want to mention, in conclusion of all this, that, we also share your passions and your frustrations. We live here in this community also. We have kids and families. And I just want to say that I've learned a lot from you tonight and greatly appreciate your comments. And one of the biggest things is, what a wonderful opportunity for us to share some experiences and get some information out there, but in such a respectful way. I really want to say thank you for your conduct tonight. It was absolutely refreshing, and I know though this is a tough issue, but we continue to do this. Please reach out to any of us on the panel, reach out to the council members. We have business cards in the back. We would love to sit down with you some more and talk to you some more. If you've got some additional questions, we will make the time for you. And again, thank you so much. I look forward to working on this situation in partnership with you, the community, council, community organizations. and have a great evening.